Good evening, everyone. Thank you so much for joining us tonight for Demystifying Estate Planning. My name is Marco Lima, MRA Advisory Group. It's a pleasure to have you tonight on summer night with a few more weeks left in the summer. And thanks for taking the time to talk through this very important topic. Not the most exciting topic to talk about, however, a very, very important one. Just going to leave one more minute to just allow people to sign in. A couple announcements, if you would. This is we'd love to have a very interactive discussion today. Please use the chat function of the tool. If you are logged in, you should see a bar in the bottom of your Zoom video. And right around the middle there to the left, there's a chat button. So we'll make sure to use that place. So a lot to talk about. Just as we get started, this is we're going to go over some very basic concepts in the beginning, but and also talk about some general and very specific actionable steps. And you want to stay tuned to the end because there are some guides that I love to make a reference to, so you can use starting shortly after this presentation. And I also have a special announcement to share with the group. So without further ado, let's get started. Again, thanks for joining us, and we'll be starting. So on a very basic note from our compliance department, this is a general knowledge webinar. Topic about estate planning. Please do not take any of the content here as actionable advice. As you will learn today, there are few professionals that need to be involved in the construction of an effective estate plan, one of which is a financial planner, such as myself and our members of our team here at MRA Advisory. You certainly could benefit from putting together your documents with the estate planner, lawyer, legal professional. And a lot of times having an accountant is definitely extremely important. Okay. Why? What's the, understanding the essence of our estate plan? Just from a statistical standpoint, it's not a very exciting topic. Let's call it what it is. But just to give you an idea, only 63% of Americans they don't have a will or trust in place. And those that do have, roughly 10% of their documents are out of date. So the myth here is that most people think that they need to be wealthy to have a estate plan. There are two very big concepts that I'd love for you to kind of remember from today's conversation. One is control and order around your estate. And we'll talk about those. And also the other concept is direction. So we're going to go through that as we move along these slides. Again, if you have any questions, I encourage you to start using the chat function. So start accumulating them. If you have any burning questions that I might be able to entertain, we'll certainly be able to get through it tonight. The importance is really it's really order, control, and direction. I was beginning to allude. It's safe, a proper estate plan really safeguards your assets, dictates who receives them, appoint guardians, independents. And without an estate plan, really what we're talking about here is giving the state the upper hand on the decision on the distribution of your assets. So it's a pretty scary thought if you don't have a will. The state does have a process. It's a formal probate process. There's a whole section of law just around inheritance and estate and probate. However, it is truly up to the state that you live in to make decisions around your assets if you do not have the proper beneficiary designations or do not have a will, potentially a trust, and so on and so forth. So it's extremely important that I would say if we're talking about passing and going to meet the Lord. So we're talking here is, your work, your life's work, if it's totally without order and how it's going to be passed along, you're truly leaving not only leaving major issues for your heirs. So you want to have this as straightened out as possible, and we're going to talk about specific ways to do that tonight. The reasons why people avoid it, obviously, you have to talk about mortality here, and if you're, well, we all think we're going to live forever. I get it. But, certainly doing this financial planning and this journey as a firm and personally for over 20 years, we go through this process dozens of times a year with clients or relatives of clients. It's a fact of life, right? Death and taxes. We'll talk about more about those today. But certainly people get turned off because it could be some complexity around that. We'll try to demystify some of these complexities today. And it's not a fun topic. And sometimes, especially within couples, there's occasionally divergency in how you want to pass on your assets. And sometimes could be some contentions there. And those definitely need to be addressed. One of the most common questions we do get is the difference between a will and a trust. That's basic. So the understanding the key distinctions of a will and a trust is really important here. So let's kind of talk about these for a minute. So a will is a legal document that outlines the distribution of your assets upon death. So really, a will doesn't really take into effect. It only takes into effect after you pass away. A trust, however, could only take effect when you pass away, but there are several trusts that are actually put in place while you're alive. And there's several reasons you want to do that. One of which is basically you want to determine a portion of your estate to a trust, and we'll get deeper into that in a minute. So you can have control of how these assets are distributed to your beneficiaries. So it's a very personal thing, and then it goes from every case from case to case. Okay. Speaking about legal authority and probate process, so will only takes effect, like I mentioned earlier, wills only take effect upon the testator, the person's death, and most through probate, which is through the courts to get settled, and it could be very time consuming, in a lot of cases costly. When we talk about trust, they function and they pass on assets to beneficiaries almost immediately upon your passing, and they do bypass probate. So it's a more efficient way to distribute your inheritance, and candidly gives a lot of privacy as well. So when a probate process is actually a public process. So if you are ever interested to find out what your neighbors, if your neighbor goes through probate, you will find out. You can actually get a copy of the will and things like that through the court system because it's public. Okay, so privacy, control, direction, distribution, those are the big keywords for you to have a trust. And then more on control and flexibility, it speaks to the level of control and flexibility as well. So a will is going to give you your wishes upon your passing, and the trust gets even beyond that because it's an entity, if you would, that could exist well beyond your passing. They're type of trusts that exist for generations to provide income and resources for a family. Whereas the will, once it's done with it, is done, and the trust lives, it could continue. So that's that. And again, folks, please use the webinar chat for questions. Okay. Tax efficiency and privacy. really, the trust could, not all the time, offer some tax benefits and to avoid probate. And Texas, it's, from a taxation standpoint, we're not living in a very difficult times right now, because one of the biggest taxes levied on us here are the death taxes if you are subject to it. So death tax rates starts at 42%. However, through the 2019 tax reform, the exemption from death taxes has been increased quite a bit. And for this year, the exemption is over $13 million. What does that mean? That means if your estate, your assets upon your passing, and the estate is really a summation of everything you have, including life insurance proceeds, crosses over 13 million, a dollar over will be taxed at 42%. So most people would not be exposed to death taxes at this rate. So one of the main things to note, though, is the 2019 tax reform actually expires next year, and whoever our next president is, and however Congress's form is going to have to deal with many issues related to taxes, including death taxes. Now, the provision in the law really states that, if nothing is done about it, the exemption drops by half, which basically, is roughly $6.5 million. And if your estate is over $6.5 million, you certainly would be exposed. What we've noticed over the years, whenever there's a tax reform or there is a tax change, you always tucked in at the end of the bill this whole exemption thing, in a sense that historically, and I'm not getting political, I'm just stating the facts. Historically, Republicans look for eliminating or increasing the exemption from death taxes to the most they can, while Democrats tend to bring it down. Perhaps a little bit of a conspiracy theory here. Our national debt has been growing to unbearable levels. For this time around, I think both Republicans and Democrats here will be looking to potentially reducing the death taxes exemption just to generate additional revenue to support and pay off the debt. So watch out for that. And so there's a very, very compelling reason to really make sure. And how do you avoid that? That's the question. Definitely another webinar altogether, but certainly there are instruments and techniques that you can do to reduce the value of your estate, hence reducing the potential of tax liability. Now, so some states do charge or levy death taxes. The state of New Jersey used to be one of them. Interesting enough, we're in the most taxed states in the country. But in 2018, they did away with death taxes. So it is death tax free to die in New Jersey, everybody. So for now, but that could definitely change. So those things also relates to not only the potential death taxes, but also taxes on the assets themselves. And we'll talk more about that in a bit. Definitely, there's some things that some documents that are a must within the estate plan package, if you would. And we'll talk about some of them. And beneficiary designations. Most people do not spend a lot of time on this. So for those of you participating, do you have a document somewhere that clearly tells, clearly tells or states all your accounts, all of them, and who are the beneficiary of all of your accounts? So just imagine that for a moment, and I hate to bring you there. Usually between husband and wife, there is communication and understanding about what's what and where everything is. Sometimes there isn't. Sometimes one partner handles all the finances, the others just kind of handle other parts, like such as healthcare. There's no right or wrong answer here, but the point is, I lost count of how many times heirs have been scrambling looking for accounts, and sometimes accounts appearing 2 to 3 years later after the passing of someone. So kind of jumping ahead here, but there needs to be an inventory of all of your accounts. We spend a lot of time with that when we work with our financial planning clients to help really list, but also there needs to be a step further and beyond that. Who are the beneficiaries? So question for everybody here: who are, for instance, the beneficiary of your checking account? So think about that for a minute. Sort of a tricky question. Most banks don't assign beneficiaries to accounts. So that account by itself will be subject to probate. So something to think about. You open a CD, who are the beneficiaries? Things like IRAs, brokerage accounts, especially here MRA takes special care to make sure everything's assigned. But truly having an old-fashioned inventory of everything that you have is key. For those that may have minor children, certainly guardianship provisions are extremely important. The only note there is if they are minors and you really don't want to, you could, nothing prevents you from doing that, but you perhaps want to avoid assigning a minor as a direct beneficiary of any accounts. Why? Because no company would pay directly to a minor. They're prohibited to do so. They would subsequently pay to a guardian of majority age. And if the minor is made the direct beneficiary, what we're looking here is adding another layer of complexity to the distribution of assets, because we're now adding a child's court into the matter. I've worked with cases where money was stuck in child's court for 2 years and the actual beneficiary needed. So it's virtually kind of a nightmare. So you definitely, as much as we love and meet with minor children, they're not directly beneficiaries. It's in my case a trust, and then with that also, the person that's going to handle the trust. Insurance policies are extremely important. A lot of people have work policies they kind of sign up for when they join the company. Take a look at who the beneficiaries are. I've had scary meetings just on beneficiary designations. A quick one that I can come up with, a couple, second marriage for them both. We did a beneficiary review. They brought all the papers and it was written on the papers, but when I reviewed it, the former partner was the beneficiary on the life insurance. As you can imagine, that became a pretty contentious meeting. So you really want to have a good understanding who are the primary, and a lot of times it's good to assign contingent beneficiary as well, and so on and so forth. When we have a financial plan, it's much easier to track. It's kind of your account footprints, and generally, it's a common around financial planning, but also estate planning as well. Having many accounts, it's not investment, especially for investment, it's not investment diversification, is accounting nightmares for you and your heirs. So try to have as little accounts as possible, very consolidated, very easy to understand. Just kind of for a moment, let's picture somebody picking up the ball here and having to settle all this. The more accounts that you have, the more works, the more contacts you have. So you just gotta be careful. Obviously, you have to take it into account, the need and importance of each account. But having an old-fashioned list of everything, and I'll talk about more about that for a little. Digital assets inventory. So this could be also another area that we all need a little bit of help here. So, how do you close a Facebook account of somebody that's deceased, or your social media or Instagram, all the subscriptions that you have? Where are the passwords? What are the what the secret phrases to get it going? Is this stuff is when you pass, these things are all have to be dealt with, and people I'm seeing scramble a lot to get things set, and also been going through with clients, experienced personal loss in my family as well. Every time you go through a moment where you have to kind of dig, there's brings back memories, and it makes it harder to heal, right? If I can be real here with you tonight. So what we're talking about here, this is pretty old-fashioned, but there needs to be a binder, a piece of paper out there somewhere that has all this information, as your estate planning documents, as a list of accounts, the contact information of every professional involved behind that account, your passwords, your usernames. It's kind of a joke, but it's really not a joke. So most people have that, and then they have it all hidden. Nobody knows. So it's the equivalent of not having it. So make sure somebody knows what's going on and where to go. Generally, it's something you put in a safe deposit box or in a very special place, but make sure a trusted person could get to these documents when needed. So let's talk about a little bit avoiding common estate planning mistakes. And there are some pitfalls there that are maybe basic, but they're relevant to talk about, sometimes overlooked. So, failure to update a beneficiary or neglecting to consider the tax implications. So by rule, or if an asset does not have a beneficiary designation, it will go to probate, and once in probate, there's the way the probate is. We have to be accompanied by a will, which would then the probate court will follow the wishes listed in the will. And in the absence of a will, probate law will fall into play, which will basically, you now have an asset with no beneficiary. So, the basic things that you can imagine will come into play if there's no will. So it's, the law is, it's going to look for next of kin. It's going to look for, spouse. It's going to look for, first relatives, second relatives. But candidly, anybody could make a claim on the state, and they could say, well, and one beautiful summer night, having drinks, he promised me to leave me $100,000, and you can fight and you can contest that. There's nothing written around those wishes, so that could be contested. And basically, insufficient documentation can lead to ambiguity and disputes, and I've seen it even even when everything is done as much as possible, as well as possible it can be, there's definitely ambiguity. In the area of estate settlement is truly a crazy one. I've seen, unfortunately, really good family relationships break apart for very little, for disputes around inheritance and things like that. So hopefully it's not your case, but in every event we were talking about here, giving you choice and control, as well as direction of what happens with your life's work as you pass on. So this is the importance of all this. one very important document to have in place is a healthcare directive. So those of you who have gone through surgery, whether elective or emergency or whatnot, there's always, if you don't have a healthcare directive, the hospital makes you sign one. That's when decisions about life and death, come into play in terms of do not resuscitate, do I want to be in a vegetative state? So having that pre-written, pre-established, it's, your decision that you make, definitely not a good one. But otherwise, you might put your family and your loved ones in a bind because they may need to make that decision for you without being able to consult you. And they'll be guessing, and I've seen it happen if they ever made a decision. So a healthcare directive is what it says. It's the directive of what you want for you if you unfortunately are in this situation. Okay. One more note about the chat function, folks. If you have any burning questions, I'll be happy to do that. Failure to plan for incapacity. Well, so unfortunately, the concept of the diseases like Alzheimer's and things like that are very prevalent in our society. We don't have a cure for those things in there, but if you're incapacitated, somebody needs to make a decision for you in every possible level, even financial, physical, and even emotional. And having proper documentation how things are handled is key here. Executor choice. So executor, at the risk of being basic, is the person or persons that you're going to trust to make all this happen in case you're no longer around. So there are a lot of people are very blessed to have somebody that can handle everything that they trust, both from a financial and good decision making stand of view. But there are those that, for instance, I've seen cases where parents would say, "I would trust my sister to take care of my children, but I would not put a dime on her hand because she'll be mismanaging." So what you do there, right? So there are some controls, and that's where you can put it in. That's where a trust come into play. I think there'll be more on trust, just speaking about those. So what trust is, in essence, is the way I like to describe it. It's adding a visual component to things. Think of a trust like a box, and a box that's totally initially empty, and what goes in it is truly whatever you want. It could be your investment accounts, it could be your house, it could be life insurance policies, it could be collectibles. And why would you put all those things inside that box? Because that box, what comes with it is the ability to create a key. And the key will have a lock, rather, they'll have a special key. So that key, you will be given it to a person or a set of people that only them can open. And you can also say under certain conditions. So for instance, if you have minor children and they are in their teens and something happens to you, definitely advisable to consider a trust, because you certainly, number one, something happens to you while they're minors. We already talked about that they shouldn't get the money right away because they're minors. But secondly, upon turning 18 or 19, you don't want them, conceptually, you don't want them to have access to a significant amount of money because perhaps they're not fully matured on that end. I could certainly speak to myself about myself. The 18-year-old version of me really should never, definitely could not or should not have had a lot of money. It didn't anyway. But in cases, the decisions there are not could be poor. So you could add provisions to a trust that will make distributions for the children's needs, but also distribute the assets later in the children's life as they mature and can make more or better financial decisions, like upon graduating for college or 25, 30 years old, and so on and so forth. So these are highly customizable and can certainly work with people to kind of tailor them for what is better in their particular situation in terms of restrictions and how to design this key to open this special lock. Tax planning really is a big deal here. There's definitely a way you can fully avoid taxes, but there's strategies there. You can create trusts that will mitigate some of the taxes, especially life insurance trusts that they're designed to mitigate state taxes. More a deeper conversation, a more specific one. But certainly, failing to consider the tax implications can result in unnecessary financial loss. I've seen it. And then things like IRA distribution strategies, when it's for a non-spousal, what's the way to do it in order to get tax at a higher level, and so on and so forth. And then also things like, heirlooms and your digital assets. There's cryptocurrency now. Most people have some exposure to that. And those are highly sensitive and password sensitive and things like that. So how does that get passed on? All these things need to be thought about and discussed, because otherwise you have really unintended consequences and some really, really big challenges to distribute your assets. And then basically, certainly seeking professional guidance to make all this happen. I'll talk about, we have what I think is a very compelling offering for estate planning. I'll share with you, those of you that haven't looked at it, I'll share with you momentarily. But a really effective plan will have the involvement of at least 3 professionals, definitely a lawyer, a planner, and an accountant in some cases. That's really, really, really important. How we can solve today, we have a really good partnership with a firm. They're called Estate Guru. They have lawyers in, I think, every state, in which they will basically produce these deliverables in a very streamlined manner and a very, very cost-effective way to do it. So I'll take a minute to really kind of give you a quick view of the site, our site on estate planning, so you can have kind of understanding of what I'm speaking of. So it's really streamlined. It's just a 4-step process. You create an appointment with one of our advisors. You're given a state guide preparation. If you want to come on board, you sign an agreement. We will meet to talk about a very thorough questionnaire about different components of your estate planning needs, from asset distribution to healthcare to power of attorneys. We will look to actually pass it on to the attorney to create the documents, and they will produce a very beautifully binded documentation for you to make all this happening and put it together. Usually we've done one of these, and within probably 10 days or so, we can go as quickly or as slow as a client. If you haven't done it, certainly you want to do it, you can set up an appointment here, or if you work with one of our advisors, you should contact him or her to talk more through it. Pricing, most people will probably need a trust. So the pricing for, I will say, the full package is $1,250. That's comes primarily from the legal folks. It's not the cheapest place that you can get this done, but it's also not the most expensive either. For the level of work, I've seen something in the neighborhood of $4,000 to $5,000 being spent to deliver for the same deliverables. So check us out. One of the things I'll suggest is, if you have Also, we're about to get into open enrollment, and those of you who are working, a lot of companies offer legal services as a plan, so you can talk to and sign up and get a legal professional. I would say, most lawyers can crank out these documents. I would highly encourage you working with somebody that really focuses on estate planning, because the law changes quite a lot. Wanted to share with you, so if you want to get started, just follow this button. Some really helpful guides that you can start using it right now. Make them bigger for you. So just when you get to this portion of the site, it's mraadvisory.com/estate planning. You really click, and you got to put in your info to get the actual checklist. But what issues should you consider when creating my estate plan? It gets you thinking about the things you need to be thinking about more so than what we discussed today. What should you consider when reviewing your beneficiaries? So things like minor children and things of that nature are there. Will I receive a step up in basis for the appreciated property inherited? That's a mouthful. So what are we talking about here? So the current law is, on average, so you upon your passing, a lot of times there is what's called a step up in basis to the beneficiary. So the best way to describe that concept is giving a hypothetical. Let's pretend for a moment that I, Marco, bought shares of Apple for $1. Wouldn't that be nice? And those shares are worth today $10. So 10 minus 1, 9. So I have a $9 gain in that stock. So if I, Marco, were to sell those shares, I will be paying taxes on $9. But if I pass, and if those shares are outside of retirement account, my beneficiaries would have a step up in the basis, meaning their new cost is now $10. So they're not paying the $9 gain, gets sort of zeroed out. So they will only begin to pay taxes on the sell once it grows above 10, let's say, for instance, 11. So if my beneficiaries sell at $11, so they have a $1 gain as opposed to a $10 gain if it was with me. And so, but not every asset steps up in basis. So this helps you figure that out. Why is that important? Because it helps them sometimes in distributions, because if you want to be fair and even to everybody, you want to consider this portion of the estate plan. Also, what issues should I consider before closing an estate? It's a whole separate subject. Now, everything has been distributed. The person has passed away. They went through probate. They went through trust. So now you have to close the whole thing. These are the guides here that can help you get those questions. And of course, if there's something here that was not addressed, you certainly can reach out to one of our advisors, to myself, a member of our team. Will be happy to make this more customizable. So with that, just want to give a minute. If anybody has a question, please use the panel there. And then as you think about it, I have one quick announcement. This is pretty exciting for me. I am launching or publishing my first book. You guys are the first one to see the cover. So building enduring wealth for retirement should be coming up initially on Amazon this fall. So pretty excited. I started trying to jot down some of my experiences for over the past 20 years and holding the old started becoming a book. So I wrote it over the summer, and this is pretty exciting stuff. We're going to make a big splash about that, but figure let you guys take a look at what it looks like. they wanted to put my mug on the cover. I thought about it, but here it is. So if anything, you can use it to, scare away some of the bugs that may come into the kitchen, if you leave it there. But no, it's all right. So pretty excited about it. It's a how-to book. Okay, so it takes into account those of you who are clients and been following a financial planning process. A lot of those concepts are here. It's about creating a mindset and so on and so forth. So watch out, and we'll definitely keep you posted there. I don't see any questions. That means everybody should be pretty good about these things. So that is great. What I was going to suggest is certainly visit the website. The website is a good resource for you to kind of get acquainted with the process. You don't necessarily have to do this with us. We have a turnkey. The clients have used us. We know their story, so this becomes pretty easy to flow through. But the importance is doing it. And also, one last comment is, it's if you have done a estate plan, which is phenomenal if you've done it. Usually it's okay. You definitely should be reviewing it every 3 to 4 years. I don't know the situation of everybody that's connected today, but I would certainly think that after the next year's expiration of the 2019 Tax Act, there will be some changes. That's what we've been hearing from some of the professionals that are closely following this. So certainly put on a calendar for next year. But also, I'd highly encourage you to if you haven't done, then make sure you get our newsletters, because whenever there's news about these topics, such as estate planning, we're trying to be on the forefront of that. So with that, I'd like to thank everybody for joining us tonight, and certainly enjoy the rest of your summer. We're here for you, and have a blessed evening. Thank you very much.